there's two parts to this ruling, right? There is the implications for abortion rights, and then a whole host of other rights.
Yeah.
What are implicated in that second sort of tranche?
Yeah, so Alito casts skepticism, upon all unenumerated rights, and specifically substantive due process rights, and those are the rights that we have derived from the Due Process Clause of the 14th Amendment. So long history. I won't, we only have, we don't have that much time, so I won't give you the history, but this goes back to the 1900s, where the Supreme Court was interpreting the Due Process Clause to protect rights, rights to privacy, rights to control the education of your children, right? Rights to custody of your children, rights to access contraception in the 1960s, rights of unmarried people to access contraception. So what Alito is saying is that all those decisions dating back to the 1900s, illegitimate, right? So that means that those rights are vulnerable now. They're threatened. And there's nothing that would stop the Supreme Court from holding that this, Meyer versus Nebraska, this old case that said that you have a right to send your child to a school of your choice to get your child educated in the way that you want your child to be educated, that is a protected constitutional right. There's nothing that stops the Supreme Court from saying, well, that's substantive due process. That's trash. But looking forward, specifically in the 2000s, right, we started seeing the court use that same due process clause to protect the rights of LGBTQ people. So Lawrence versus Texas, which held that it was unconstitutional for Texas to criminalize, quote unquote, same-sex sodomy, that opinion relied on substantive due process. And so when Alito says these unenumerated rights, they're made up, they're trash, they don't really exist, Lawrence v. Texas stands in the crosshairs. It means that it would open the door for Texas and any other, state to criminalize same-sex conduct, same-sex sexual activity. And then, of course, Obergefell versus Hodges built on Lawrence versus Texas. Obergefell versus Hodges being the Supreme Court case that held that the Constitution is properly interpreted to protect the ability of a person to marry another person of the same sex. So same-sex marriage equality, that stands in the crosshairs as well. So abortion, Roe v. Wade is just the beginning. The Supreme Court, I think it's important for people to understand that the Supreme Court is the judicial arm of the GOP. The Supreme Court is not an independent body. It's not apolitical at all. And so what the GOP wants, this conservative ideology, this conservative view of the country, the Supreme Court now stands prepared to sort of manifest it. And LGBTQ rights are likely the next to go. But I think it's important to recognize that all sort of reproductive liberties around accessing contraception, having children, not being coercively sterilized, those things are equally vulnerable from a constitutional standpoint.
But the fact that that Alito's opinion explicitly targets Lawrence v. Texas, or at least alludes to it in a very specific manner, it's kind of a bat signal for Republican legislators around the country, because look, we gave you runway to implement all of these very restrictive abortion laws, and now we are rewarding you. We are rewarding you with this opinion. And Absolutely. Here embedded in my opinion, I'm giving you the damn roadmap to do this next. And this is the easiest way to get what you want. I mean, they're telling them in this opinion, do this next.
Right. Absolutely. It's kind of like back in September, actually, when the Supreme Court allowed Texas SB 8 to go into effect. It was kind of just like, I see what you did there. Go ahead, keep doing it. We're not actually going to stop you. And so Texas is like, cool, we'll just, make sure that nobody gets abortions in the state past 6 weeks indefinitely. And then all these other states, followed the lead. And so, Kentucky passed restrictive abortion legislation. Everybody's queuing up, having read the clear signs from the Supreme Court. The Supreme Court's not going to stop anti-abortion legislation, not going to stop anti-abortion restrictions. or rather abortion restrictions. And so the signal, it takes a lot to not see the signs in Alito's draft opinion that he's opening the door to, okay, focus next on Lawrence versus Texas. Right. Focus next on Obergefell. He's making it very plain that he doesn't believe that those decisions were correctly decided. The justices that sign on to Alito's opinion will be indicating that they don't think that those decisions were correctly decided, were correct interpretations of the Constitution. And so now it's an invitation for red states to, okay, see what you can do, right? Like maybe stop issuing marriage licenses, maybe stop allowing LGBTQ families to adopt. Maybe, let's just, let's play with it a little bit, see how far you can get before you get a decision in which the Supreme Court overturns it entirely.
So on that day in June or possibly early July, when this decision is announced, it may not be Alito's brief as we've read it today, but it is almost certainly going to be a 5-4 decision to overturn Roe v. Wade. 26 states, is my understanding, essentially in that moment will have a ban on abortion. There may be some slight variation between those bans, but basically abortion is done. Connecticut just passed a law, it's about to be signed, I think, by Lamont, that was aimed at protecting people who left, let's say, for instance, state of Texas and going to Connecticut, so they could countersue and get back all the money that they would lose if they were sued out of Texas, and it protects them. But I have two questions, and these are the two final questions. One, can a Connecticut create a law that would inhibit Texas' ability to have their law follow that Texas citizen to Connecticut to get an abortion, let's say? Mm-hmm. A, and B, what can a state do? We haven't really contemplated this, but this is something to contemplate. In 2024, even if the Democrats hold the Senate in 2022, the odds are against them in 2024. The House is probably going to be gone by 2024. It's not impossible to imagine that Donald Trump or Ron DeSantis or whomever it is going to be president. When the Republicans get all three branches of government, they could pass a federal ban on abortion. Is there anything the states can do in that instance?
No. Well, I have to think more about it, but So what you are suggesting is absolutely likely, and the Democrats should have been planning for this possibility. I think that for so long we have been sort of leaning on the existence of Roe v. Wade, right? We had been just assuming. I mean, Supreme Court justice confirmations have been around. Whether a justice would or would not vote to uphold Roe v. Wade. So for so long, we have been relying on the Supreme Court's decision and abortion being protected as a constitutional right. With the demise of Roe in the summer, in a month or so, it now leaves the political branches open to do what they do. And I think that we are fools to believe that the next step in the abortion fight is not, or the next goal for Republicans when it comes to abortion is not a federal statute banning abortion in the U.S. entirely, right? If you believe that the fetus is a life, you're not satisfied with a life being protected in Texas but killed in California. If you believe that abortion is murder, you shouldn't stop until this murder isn't happening all over the country. And so that's what a federal law, a federal piece of legislation would be to prescribe abortion across the country. At that point, what could states do? I think it's states could do very little. Like when you're facing a federal ban on abortion, just like but I think it takes creativity to respond to something like that, right? So since 1973, we've had federal license to get an abortion. And so, anti-abortion folks have had to operate within the constraints of that law. And I got to say, they did it quite creatively and ingenious. And, they did a great job since 1973 in whittling down the abortion right to where it stands today, which is not very good. And now this not very protective right that we have is about to be overturned. So I think that folks who support abortion rights have to be just as creative as anti-abortion folks have been since 1970. They were operating under a federal regime that they didn't like. They did a great job to make abortion inaccessible. So we may be operating under a federal regime that we don't like, and we're going to have to act creatively to make abortion accessible to those who need it.
Kiera Bridges, law professor at UC Berkeley School of Law. Thanks so much for your time today. Really appreciate it.
Thanks for having me.